Hello, I'm Dan Marr from the Nashua law firm of Hamblett Kerrigan. I'm going to be talking today about in New Hampshire how a company, an employer, can protect from their former employees stealing their customers or taking their customers from them. So you have a situation where you have sales force that you're bringing on board, you're paying them to get a good relationship with your customers, and you're concerned that when they leave, they'll be taking those customers with them. They'll be taking the goodwill from the company. And while in situations where you try to do a non-compete saying you can't work in this industry for this period of time, those are narrowly construed to really get down to the non-solicitation agreements in most situations. In New Hampshire, you can enforce non-solicitation employment agreements, and they don't have any restrictions in regards to when they're signed. Non-competes have a restriction as to if they're offered as part of the new employment, they have to be offered before the person accepts. There's also a limitation on if somebody's getting really small wages, they can't get enforced. But none of that applies to the non-solicitation agreements. In the federal arena, the National Labor Relations Board had issued a rule saying non-competes across nationwide employment non-competes are unenforceable, but a Texas court granted an injunction nationwide, and it's still applicable. So the National Labor Relations Board, particularly under the current administration's funding, isn't probably going to be going after taking the fight of the non-competes. But non-competes are not really as helpful for somebody to prevent the other person from working. You really want to prevent them from taking your customers. The fact that they're still working in your industry and maybe getting new customers within your geographical area, well, that's why you have other employees that you're trying to compete in. That free competition is generally going to be something that the courts are going to think are fair and reasonable for employment non-competes. So the non-solicitation, though, on the other hand, of don't take the customers, and also you can add in don't take our employees for a period of time. That's often common in a non-solicitation agreement. In New Hampshire, is generally going to be enforceable. You certainly want to look at the choice of laws for certain things. I can tell you, strangely enough, that I've been dealing with some employees in India that have an employer in India, of course, and then we're contracting with them for clients. There's a New Delhi's High Court that specifically says non-competes in India are considered also non-solicitation agreements, and they're banned for employment situations. So in India, by way of example, and that's why you want to know the country that the employers deal with, particularly when you're dealing with remote employees, in there they can't have an enforced employment non-solicitation. But here in New Hampshire, you have a New Hampshire salesperson. They're doing hits with New Hampshire clients, and you want to prevent the relationship, or they maybe there's somebody that's servicing this client. They may not be the salesperson, but they might be servicing this client. You want to make sure that when they leave, they can't continue on with that. You can have an enforceable non-solicitation agreement. I've done those, and if I'm going to do one of those for the employee, one of the things I want to do when I'm representing the employer is to put some teeth in it and state that for the employer, if the employer prevails in one of these claims, or they do anything to enforce this claim and they're found to be right in enforcing the claim, they can collect their attorney's fees from the employee. Now, some people will say it's only fair to have prevailing party gets their attorney's fees. I'm not going to be fair when I'm representing the employer. I'm trying to represent the employer. Contracts are not supposed to be fair. They're not meant to be that way. Judges will determine whether or not how much they're enforceable. But I want the salesperson to think twice before they leave my client and take the customer with them. I want some skin in the game for that client. And then I also for that employee. And then I also want to, if I'm in a situation where I have a client that has a non-solicitation agreement, the employee's left and gone to a competitor company, I want to provide that non-solicitation provision to the new employer, and I want to explain to them that if they're continuing to allow that new employee to take those customers of ours, that they're helping him violate the non-solicitation agreement for their benefit, and it's what's called tortious or wrongful interference with contractual relationship. So if we're going to go after this person, we're going to be threatening the former employee with a breach of contract and the attorney fee provision perhaps in that contract. And then the new employer, we're going to be going after them for solicitation or for wrongful interference or tortious interference with a contractual relationship, being this non-solicitation agreement. And that might stick very well with the court, for a court to realize that when you're taking Jack away from Acme and they're going over to the Beta company, and Jack is encouraged to take all his customers with him, even though he has a non-solicitation agreement, Beta is benefiting from that, and Beta should be paying for that. So that's a risk for Beta, and Beta might decide they don't want Jack anymore, or they may actually make sure that he stays within the parameters of taking on new customers. And so that can be very effective when you're dealing with these situations. So getting the non-solicitation agreement, and the non-compete, if you throw it in, it's probably not going to be enforced anyway. It's going to be down to the non-solicitation. And then putting an attorney fee provision in it. I've negotiated those agreements. And then enforcing them with not only a threat to the employee, but a threat to the new employer, saying, when you're going forward with this, we're reminding you that there's this non-solicitation agreement, and if we find out you're helping your new employee violate that agreement for your benefit against us, we're coming after you for wrongful or tortious interference with a contractual relationship. I'm Dan Marr. I've been here at Hamblett Kerrigan for about 36 years. I'm practicing in New Hampshire and Massachusetts. I can be reached, licensed both. I can be reached at 603-883-5501, 603-883-5501. You can also check out our website, NashuaLaw.com, and you go to my link, and then from there you can click to my weekly blogs that are all by topic. Look forward to working with you. The opportunity arises. Thank you.